Buenos días, soy
Good
Carla
morning.
Sáenz.
My name is Carla
Vamos a dar
Sainz,
inicio a esta
and
sesión
we will
sobre un
get this
modelo
session
de
started
contratos para
regarding
ensayos clínicos
a
regional.
model contract for
Antes de
regional
iniciar
clinical
propiamente la
trials. Before we
sesión,
get started with the
voy a
session,
ocuparme de algunos
I'd
temas
like to take
de
care of
logística.
some logistical issues.
Los que quieran escuchar todas las
For those of
presentaciones y
you
toda la
who may
discusión
want
en
to
español,
listen to all of the
pueden o
discussion and
mantenerse en la
presentations
sala
in Spanish,
principal
you can stay in
o,
this main room.
ir
And
al
if you want to listen
pequeño
in Spanish,
globo, la
or
figura
you
del
can go
mundo que
to
dice
the
interpretación
interpretation feature, which
y
is the
ahí
globe icon at
apretar
the bottom of your Zoom
español
screen,
cuando
and you can
haya
select
alguna
Spanish
intervención en
from the
inglés.
pop-up window
Welcome everybody. I'm
whenever
Carla
somebody speaks in
Sainz.
English.
Most of this session will be in Spanish. If you want to listen to the presentations and discussion in English, please go to the little globe that is on the bottom of your screen and click on English. Ahora sí, continuamos. Bienvenidos a una nueva sesión de la
Moving
serie de
on,
seminarios virtuales sobre
welcome
temas
to a new
relacionados con
session
los
on the
ensayos
series of
clínicos. Esta
seminars that
sesión de
relate to
seminarios
clinical
virtuales
trials.
es
This
coorganizada
seminar
por el
on clinical
Programa Regional de
trials
Bioética, que
is
hace parte de la Unidad de
organized
Ciencia y
by the
Conocimiento para el
regional
Impacto del
bioethics program
Departamento
that
de Evidencia e
is
Inteligencia para la Acción en
conducting some
Salud
work
de
on
la
the
OPS
impact on
y
behalf
la
of
Unidad de
PAHO,
Calidad y
and it
Regulación de
involves the
Medicamentos y Tecnologías
quality,
Sanitarias de la
medical
OPS,
quality
que
and
hace parte del
regulations
Departamento de
division,
Innovación, Acceso
and
a
they
Medicamentos
work
y
as
Tecnologías
part of
Sanitarias.
the Department of Innovation,
Este es uno, ya hemos perdido la
focusing
cuenta, uno
on medical devices and other health devices.
de muchos seminarios que hemos tenido,
We've
pero para
conducted
los
a
que nos
number of these
acompañan por
seminars,
primera
and
vez,
really we've lost count.
les
But for
hacemos
those of
saber
you
que
who are
pueden
joining us here
mirar
for
las
the first time,
grabaciones
I'd
de
like to
los
remind you
seminarios
that you can
previos
see
en
the
inglés y en
recordings for the
español,
prior seminars, both in
bien
English and
entrando
in
al
Spanish,
portal de
by
ensayos clínicos de
accessing
las
the
Américas de
uh,
la OPS
Clinical Trials for
o
the
al
Americas
Programa
website at
Regional de
PAHO, or
Bioética, a
by
la website del Programa
accessing the
Regional de Bioética.
website for
Vamos a
the Regional
compartir los
Bioethics
enlaces
Program. We will be
por medio
sharing
del
the
chat
links
durante
to
la
both
sesión.
websites during the course of today's session in the chat
Algunos
room.
temas adicionales de logística.
Additionally,
Les agradecemos enviar sus
we would be
preguntas por
grateful if
medio
you
de la
could submit your
funcionalidad
questions
de preguntas y
through the
respuestas
Q&A
del
function
Zoom.
on Zoom.
Los comentarios para compartir
Any comments,
enlaces o
any links that you
presentarse,
may want to
pueden
share, or if
usar
you
el
just
chat,
merely want to
pero nos es
introduce
más
yourself,
fácil identificar
you
las
can
preguntas
choose to do so in the
para
chat.
si
But for
usan
us to
la
manage the
funcionalidad de
questions and
preguntas y
comments a little bit
respuestas.
better, we'd
Las
be very
preguntas
grateful
pueden
if
ir
you
en
submitted them
español, en
through the
inglés o
Q&A
acaso
function.
en portugués.
Your questions can
Quiero
be made
resaltar
in
que como en
English,
los
Spanish, or
otros
even in Portuguese.
seminarios de esta
I'd like to
serie,
highlight that,
no
like
se va a
prior
dar un
seminars in this
certificado por
series,
la
we will not be
participación.
issuing a
Se grabará la
certificate for
sesión
attendance.
y si
The
usted
session
quiere
will be
recibir la
recorded, and if you
información
want to
sobre esta
receive
sesión,
any
sobre
information about
con
this session
el material relevante,
or
por
about
favor
the
suscríbase a
corresponding
nuestra red
materials,
regional de
please
investigación
subscribe
ética.
to our
Nuevamente estará
regional
toda la información en la web del
bioethics
Programa Regional de Bioética, en
research
el portal de los ensayos
network.
clínicos.
You can find this
Sin
in
embargo, si
the
se
clinical
suscribe a la
trials
red de
program
investigación
website.
ética,
But
podrá
if you join
también,
the network,
podrá
the
también
Regional
conocer
Bioethics
cuál
Research
será,
Network, you
les
can
adelanto, el
also
próximo seminario
get information on
que será
upcoming
también
webinars.
sobre un tema
And the
central de
next
nuestra
one
agenda regional
will also
pendiente,
address
que
another
son los
priority
protocolos
item at the
preaprobados y
regional
será el
level
18 de
for
junio.
us. And these are pre-approved
Ahora bien,
protocols,
la
and that's
sesión
scheduled
de
for
hoy
June 18th.
resulta de
Now
un
then,
esfuerzo
today's session stems from an effort
del que ustedes han escuchado en
that I'm sure
oportunidades
you've heard
anteriores.
of
De hecho,
in
tuvimos
prior
un
opportunities.
seminario
In
anterior
fact, we
enfocado
had
en
a
este tema.
previous seminar
¿Por qué
that
la
focused on
OPS
this
está
topic. Now,
trabajando
why is
en temas
PAHO
de
working
contratos para
on
ensayos
issues related
clínicos?
to
Tuvimos
clinical
un
trials
taller
contracts?
regional en octubre del
We did have
2023
a
sobre
regional
la
workshop in October
implementación
of
de la
2023
resolución
on the implementation of
75.8
Resolution
de la OMS
75.8
que
of the
busca
WHO
fortalecer el
that
impacto y
seeks to
la
strengthen the
eficiencia en los
impact and
ensayos
the
clínicos.
efficiency of
En
clinical
esa
trials.
reunión regional,
During that
eh,
regional meeting,
distintas partes resaltaron
different
que una de las
parties
dificultades más grandes
highlighted that one
iniciar
of the
los
key
ensayos clínicos de una
difficulties
manera
to
ágil en
initiate
la
clinical
región
trials in an
son los
expeditious
contratos.
form in the
Hay
region
una diversidad
involves
de maneras
contracts.
en la
There's a
región
great deal of
de hacer los
diversity
contratos de
in
los ensayos clínicos
manners or
y por eso
forms
se
in which
acordó la
contracts are
importancia de
entered
sumar
into in the
esfuerzos
region. And so
para
we embarked on
establecer
an
una
effort
suerte de
to
modelo
work
regional de contrato que
jointly to
incluya también
establish
el
a
contenido
regional
central de una
model
póliza de
contract
seguro
template that
para ensayos
includes an
clínicos
insurance
que
policy for clinical
facilite la
trials that
realización
can
de ensayos
facilitate
clínicos en la
the
región. Los
undertaking
ensayos
of clinical
clínicos
trials in the
científica
region.
y
And we're
éticamente
talking
sólidos,
about contracts
capaces de
that are
producir
scientifically and
conocimiento
ethically
valioso
solid,
para nuestra región.
and they
Y
can
realmente el
contribute
ensayo Heracles, en
enormous
que seamos
knowledge to
capaces
the
de sumar
region.
esfuerzos
And
desde
we
distintos
believe that we
países.
were capable
Es
of
por
joining
esto
forces to come
que
up with a
el año
proper template
pasado
to do
la
so.
OPS
That is
inició
why
este
last year
trabajo
PAHO started
y hemos
this work,
compartido la invitación,
and we've shared the
pero
invitation,
está también disponible
but
en
it
el
is
portal
also
y en la web
available
de
on our
bioética
website and
un
on the
seminario
bioethics
previo
website,
de la
and
sobre
it
nuestro
involves a
trabajo
prior
en este
seminar
tema, mostrando la importancia
that
de
focuses on the
acordar un
work that
modelo
we've
básico de
undertaken in the
contrato.
region. And
Pero
so our work
además,
involved
en
coming
ese
up with a
seminario se
basic
presentó parte
model
del trabajo
contract.
que la OPS venía
Much of the
haciendo,
work
específicamente un
was based
mapeo
on
de las
work that
normativas
the
regionales
Pan
hablan
American
sobre
Health
estos temas,
Organization had
donde
done
se
for some
mostró que
time
no hay
after
ninguna
conducting a mapping at
divergencia
the
desde
regional
la
level.
región, simplemente que no
And
hemos
we discovered
pensado
that there
estos temas
wasn't that
de
much
una manera
divergence in the region, but we
conjunta,
never thought
buscando
about these issues in a joint fashion.
acordar el
And we
contenido.
never made an
Todos
attempt
hacemos
to
básicamente lo
come to
mismo,
a
pero de una manera un
consensus
poquito
on the
diferente.
content for this instrument. We
Adicionalmente,
all
este
more or
mapeo
less
de
do the same
normativas
thing, but we do so in a
regionales
different
se
way. So
realizó
based on
un
this regional
mapeo de
mapping effort,
expertise en la
we
región y
created a
establecimos un grupo
map for
de trabajo
expertise
de
in the region, and
expertos
this led to the creation
en
of
lo que
a
se identificó también en
experts work
Brasilia,
group
que era una pericia muy
that
poco frecuente,
was
que es
established in Brasilia
esta pericia
with
legal
expertise
sobre la
that we don't
conducción, la
normally see.
realización de
And this
ensayos
was
clínicos.
legal expertise
Luego,
related to carrying out
desarrollamos un
clinical
borrador
trials. We
que
also
se ha
developed a
discutido con este
draft
grupo de trabajo de expertos,
instrument
se ha
that we discussed
revisado a la
extensively
luz
with
de
this
la
expert working group.
retroalimentación que hemos
And
recibido por
we
parte de
also
ellos,
relied
que
on
incluyen
the
distintas
network of
perspectivas
researchers
que
that commented
dirán a
on the
continuación,
template and that
y,
included a number
también
of
se ha
different
enriquecido
perspectives.
con
The
la
document has also
retroalimentación de la
been
oficina legal
enriched
de la
with the
OPS.
feedback
Es un
provided
gusto
by
para
the
mí
legal
presentar al
office
equipo de
at PAHO.
trabajo
So
para
it's a real pleasure for me to
para
introduce
este
the work
proyecto
team
de la OPS.
for this PAHO project.
Me refiero a
And I'm referring to
Carlos Burger.
Carlos
Él es abogado,
Burger,
doctor en ciencias
who is an
jurídicas y
attorney.
sociales.
He has a Juris
Es
Doctor
especialista en
in
bioética
political
y ética de la
science.
investigación.
He's an expert
Coordina el
researcher
Comité
in
de Ética
bioethics,
Central
and
del Ministerio de
he
Salud de la
coordinates
Provincia de
the
Buenos Aires.
bioethics
Es
division in
profesor
the
de ética de la
Ministry
Universidad de
of
Buenos
Health in
Aires
the
y la
province of
Universidad de La
Buenos
Plata.
Aires, and he's also a professor
Otro
at the
miembro de
University of
nuestro
La Plata.
equipo de trabajo
Another
para
member of our work
para este
team
tema es
that focused on this project is
Adriel es
Daniel
abogado, es
Adriel Roima.
asesor
He is
legal
an
de la
attorney. He's a
Dirección
legal
General de
advisor for
Docencia,
the
Investigación y
General
Desarrollo
Directorate
Profesional del
of
Ministerio de Salud
Research,
de la
Faculty,
ciudad de la
and
Gran Ciudad de
Professional
Buenos
Development
Aires en
for the
Argentina.
Ministry of Health in
Miembro
the city of
de
Buenos Aires,
distintos comités
Argentina.
de ética
He is a member of
en
various ethics
investigación
and
en
bioethics committees
Argentina, de la Clínica de
that
Maternidad
focus on
SOS
research
Argentina, de la
in
Clínica de Olivos,
the
y además
maternity
es miembro
clinic
ad hoc
in
del
Buenos
Comité
Aires and the
Central de Ética y
Olivos
Investigación
clinic,
del Ministerio de
and he's
Salud de la
also a
Ciudad de
lead
Buenos Aires.
researcher for
Y
the
también hace parte de
Ministry of
este equipo
Research
de
in the city of
trabajo
Buenos Aires.
Sara Carracedo,
Another
del
member of the
Programa
work group
Regional
is
de
Sara
Bioética de la
Carracedo
OPS,
from the PAHO Bioethics Committee,
a quien también han visto en
and
sesiones,
whom I'm
en
sure
muchas
you've
sesiones
seen
previas.
in many prior sessions.
La propuesta que les
The
compartimos hoy
proposal that we will
es
be sharing
resultado de un
today
trabajo
is the
arduo de su
result of
equipo
a great deal of
y
work undertaken by this team,
yo voy a iniciar, vamos a iniciar las
and
presentaciones
we will
con
begin the presentations
Sara Carracedo.
with
Adelante,
Sara Carracedo. Go ahead, Sara.
Muchas gracias,
Thank
Carla,
you
por la
very much,
presentación.
Carla,
Voy
for
a
the introduction.
compartir
Let
mi
me begin by
pantalla.
sharing my screen.
Me parece que ahí se ve bien.
I believe you can see that. Well, welcome to another webinar, and this one focusing on the model contract for clinical trials. I will begin this session with some general considerations related to this model contract that we've been working on. I think that the first thing I need to begin with is to have an idea of what these contracts are for clinical trials. Basically, these are binding agreements that establish the rights and obligations for the parties involved in carrying out a clinical trial, but it also includes administrative and economic aspects related to its execution. Having these contracts is not merely a mandatory obligation, but it also outlines the various parties' responsibilities and commits them to their roles. So the contract addresses the financial aspects of carrying out the clinical trial, the budgets, and what have you. And in this way, we can bring more transparency and confidence for all parties involved in any clinical trial. Now, these contracts are negotiated, are created and signed within the framework of different standards. The first two involve international ethical standards for research related with human health, and it involves a number of different standards issued by the CIOMS, the Medical Sciences International Organizations. It also includes clinical best practices guidelines that were issued by the International Harmonization Conference, ICH, and it addresses those standards that address contractual regiments, civil society, and other stakeholders. And in some cases, it also includes the applicable foreign rights. And this involves external or foreign jurisdictions. Whenever the parties decide to join the contract in a supplementary way. So what is the context and the justification for these contracts? Well, good clinical practices demand that prior to beginning a clinical trial, there needs to be an established agreement to regulate financial aspects, roles, and responsibilities. And as part of this, we need to consider key aspects such as that related to any liability to any liability involving any of the stakeholders. These clinical or these issues are required for clinical trials involving medications or devices or any kind of clinical trial, and it involves national regulatory agencies, and that's why these best practices are applicable. And as part of this framework of best practices, we have this contract that is signed by all the involved parties, and it involves an insurance policy that will cover any adverse outcomes that stems from the actual research or the execution thereof. Notwithstanding the fact that best practices establish the needs and the practices of the regulatory authorities, neither the best practices or the national regulations can impose any scientific provisions included in these contracts or agreements, and we've not been able to come to a consensus on that content for those instruments. For that reason, this regional proposal for a model contract is seeking to establish minimum fundamental guidelines and provisions that will permit the execution of a clinical trial, and these minimal standard guidelines are presented in such a way that allows the parties to engage in this agreement in a harmonized way, and it includes the insurance policies and addresses the different roles and responsibilities for all stakeholders involved to ensure the least amount of harm to participants. So this confers roles and responsibilities to sponsors and researchers, and in this way we can expedite the initiation of these clinical trials. And the model that we are proposing here is part of a tripartite contract that involves the sponsor, the institution that will carry out the research, and the principal investigator. Now, this doesn't mean that there may not be other parties involved, such as an international organization. So this proposal responds to this tripartite contract because this is the most common arrangement that we see in clinical trials at the regional level. And we try to explore all of the various collaboration mechanisms possible. And in the region, the classic form of the clinical trial, it usually involves a pharmaceutical company. But we also see clinical trials where the principal investigator designs the protocol. They also provide the intellectual component of the protocol, and the sponsor primarily provides the funding for the clinical trial. So if indeed this model isn't necessarily directed to that kind of process, we believe that the guidelines, by and large, are a useful reference to achieve other forms of collaboration or other forms to work together to undertake clinical trials. Now, what I'd like to do is highlight some of the aspects of this model contract, and the first one lies in the active role being attached to institutions. Now, this is geared towards establishing institutional leadership. Institutions that carry out these types of research have an obligation to provide oversight for the project from beginning to end. And when we talk about infrastructure providers or providers of resources or human resources, we do need to have a clear-cut idea of this institutional component, and it is that institutional component that provides the operational support that is required by all of the researchers in the project. This is something that was discussed in Brazil. That is the need that researchers had to count on the support by the institution. So we need to have a research culture within the institution, and we also wanted to incentivize and strengthen the professionalization of clinical trials region-wide. Another aspect that I wanted to highlight includes the role of the researcher. The researcher is a party to the contract, given that their involvement, the principal investigator, is recognizing and accepting the terms of the contract and assumes the role of leader of the execution of the clinical trial, and by extension, that involves a commitment to support all of the participants. Lastly, I wanted to mention some of the aspects related to the scope of this. This model proposes a minimum number of basic guidelines that are legally valid and binding between parties. It promotes a balanced and transparent contract that's fair for all parties, and it ensures a clear-cut assignment or allocation of responsibilities to all parties. The contract does not seek to reproduce nor replace any ethical or regulatory frameworks that are in effect at the present time. It doesn't include all of the provisions involving good clinical practices or the national legal framework that applies. That's not the objective. Our objective for this project is not to replace any ethical or regulatory national frameworks. Another thing is that given the plurality that we see in the region at the national legal level and the institutional standards that could be applicable and that can vary extensively between countries, then the user of this model needs to adapt to certain guidelines and add other terms and provisions depending on the requirements for the applicable national authority or national institution involved. As Carla mentioned, this proposal has been worked on with an expert working group for some time. This is not the final version of the document. We still have some comments that we will be receiving, but we hope that this will be a product that will be easily implementable, that users can use as a reference to create their own contracts. And the idea is to promote the execution of clinical trials and that we strengthen the governance aspects of clinical trials at the regional and national level, including all legal aspects that apply to clinical trials contracts. And in this way, we can strengthen the execution of clinical trials with the inclusion of broadly accepted best practices. Carlos will give us more details about this, but these are some of the minimum requirements or guidelines required or included in this model contract. They number 21 in total, and they address general aspects, the objective of the contract, who the parties are, what international or national standards apply, the authorization and institutional capability to carry out the clinical study, the background of the researchers, requirements and responsibilities for the principal investigator and the research team, the management of the research product, what is required for the clinical trials based on ethical considerations, how documentation for the clinical trial will be managed and archived, compensation for any harm to participants and insurance policy, the publication of the clinical trial, responsible research conduct, the IP rights for the sponsor. So these are basic guidelines that will serve as a template for users to establish a safe, transparent, and fair contract model to undertake these clinical trials while at the same time observing international standards. Thank you very much, and I'll yield the floor now to my colleague who will give us a few more details about this. Carlos? Good morning. Welcome to all of you to this second seminar. This is really an activity that the Pan American Health Organization began some time ago that creates two different spaces that are very different in managing clinical trials. We have the legal, juridical space related to the contracts, and this also includes ethical considerations. So what links the participant with the clinical trial is informed consent through its process with all of the guarantees and rights therein, and the document is a reflection of the allocation of responsibilities to participants and the parties involved and the logistical legal considerations that exist between sponsors, institution, researcher, investigator, civil responsibility, or rather liability issues, financial issues, and other considerations related to payment and what have you. Today, I'm going to give you a presentation that analyzed all of these things that we are including in the proposed model contract. And we don't have time to cover every detail, but I did want to highlight some aspects in the guidelines that I believe to be more important, and this involves some work conducted with some international consultants. So why do we need to involve all of these parties in the model contract or in the contract? Why is it necessary to include the researcher, the institution? Well, clearly we are engaging in a contractual agreement, and if there are certain parties that are not included, then the contract will not be binding on those parties. So when we speak about the legal technical aspects, the parties are the legal representatives of this agreement. And so the sponsor has certain responsibilities, such as managing the protocol, managing the payments, and these are elements that are not always included in contracts. But there's an issue in which the institution in the contract does not take on all of the activities or responsibilities that they should. So when we talk about the execution procedures, it's the sponsor that needs to cover certain responsibilities as part of their complete sponsorship. So they take on the responsibility for the clinical trial because they're also responsible for the design. That's why the risk is assumed by the sponsor for the project, and the contracted research organization is something that is not obligatory. So this organization can and also may not be part of the contract. And that's something that we need to be able to address. Another thing that led to some debate was the facilities and the various ways in which the institution could carry out the clinical trial. Now, in some instances, the institution may not have sufficient resources, and in this case, the model contemplates the possibility of the institution subcontracting the components that are necessary for the protocol. For example, we have high-risk protocols that institutions don't necessarily have the wherewithal to address for an event or something like that. And this could then lead to an agreement with another institution. The same thing may happen with some diagnostic aspects and even the transportation of patients in case of an emergency. All of this needs to be understood by the sponsor, but we need to also highlight that many times when you lack the resources, this can then lead to a subcontracting of a vendor that can close those gaps. So the first party that needs to act as the institution, as the initiator of the study. And regardless of the sponsor in addressing any claims or the coverage that the insurance policy may have, we may see that this is insurance that is paid by the sponsor, and it involves the institution and the research team. When we talk about the IP considerations, that was another thing that we debated extensively. In many cases, contracts set a minimum of established hours to carry out the clinical trials. And this is something that we discussed in committee.
What are the qualifications that the principal investigator must have in order to properly carry out the trial? The template leaves this clause very open. It could be specified in terms of hours, or also it could be simply a more general statement, such as the time required to conduct the trial. Another topic which led to some discussion is what to do with direct and indirect costs stemming from the trial. And this also opens a discussion of the appropriate mechanisms to compensate or reimburse expenses. This will depend on the institution. Usually reimbursement is made directly to the institution, which is responsible in many cases for covering the expenses that are not reimbursed by the sponsor. Oftentimes, with adverse events, these can be minor and they may be reimbursed directly by the sponsor, and the insurance policy is only activated when these events are major. However, this depends on the contract. It's all subject to negotiation, and it also depends on the sponsor's strategy. But this is the sponsor's responsibility with or without an insurance policy. Now, there was also discussion of professional liability clauses in insurance policies. Most frameworks refer to insurance covering damages stemming from the trials and procedures, but do not refer to potential negligence. In some countries, there is a reference to malpractice insurance. In this case, we recommend that there be malpractice insurance coverage, and most clinical research contracts, and I repeat, this is subject to negotiations in each case. It's not mandatory, but sponsors do tend to require a malpractice policy. This is not specified in regulatory frameworks, but it is advisable to have. Since we are assigning responsibilities to researchers in the event of malpractice, there has to be coverage for compensation as well. This is something that can affect the institution as well and its resources, and that is why it is recommended that there be a professional liability insurance that covers the trials. Also, with third-party claims, whether they're justified or unjustified, compensation provided by the sponsor has to be provided in the event that the researchers complied with the protocol and all its steps, that this is not the result of malpractice, because in such cases, compensation would be provided and would be connected to the claims that are related to the effects of a drug or with the procedures used for the trial. Then there's also a clause regarding publication. Many researchers we consulted say that this is something that varies depending on whether there is one or multiple centers. In some cases, there are intellectual property clauses which do not allow for publication, but it can also be done by specifying timeframes for publication. This is a clause that is subject to modification, and it is also subject to negotiation. On intellectual property, if we have full sponsorship for the idea and for the financial resources, there can be many different types of contracts where sponsorship is purely financial. And the original idea comes from the researcher or the institution. In these cases, the intellectual property regulations are going to be different. The financial sponsor may request that there be a transfer of data, but the intellectual property would still be the institutions and the research teams. So this is important because the intellectual property considerations will vary depending on the type of contract and the different roles. Finally, and I'm running out of time, as Sara was saying, there is also a miscellaneous clause where we apply standard considerations, for example, the application of local law if the contract is in more than one language. We allow the contract and the local contract to be the determining contract, also applicable laws, term. These are merely recommendations to facilitate logistics. If I try to apply international law in a given country, I do have to prove that that international law is applicable. So that is why we recommend that local laws in the place where the research is being conducted prevail. Also, determining jurisdiction, that will be something to be negotiated. We recommend that it be local courts when it comes to insurance considerations and for the contract when there is a contractual decision for administrative reasons, when there's financing, when the trial is interrupted, when there is a decision to suspend the investment, we recommend that you take into account the medical and clinical status of participants and to have safe measures to withdraw those participants so that they can go back to their regular care. I think that was my last slide. What I tried to do was to highlight a few points that I think are important. They have a bearing on the template, but as Sara said, these are items that are under review and in many cases will depend on the type of protocol, the types of roles the parties have. And there's one thing I omitted. We made a reference to compensation. We need to consider whether the institutions are public or private. It is possible for national agencies. In such cases, they would be covered by local resources. Again, this will depend on the type of contract. It's not that having a template or a standardized model means that the local compensation laws are going to be different. Actually, what matters is the type of institution as well as the type of protocol selected. Thank you very much. This was just a general overview. We look forward to your feedback, and I would be more than happy to answer any questions if you have them. Thank you very much, Carlos, and also Sara and Carla. I'm Adriel Rotman. I'm going to be moderating the discussion. We will now hear from other specialists who may have different viewpoints. They come from different sectors and will be speaking about this initiative and about the possibility of using a contract template. As a very general comment, I should say that attorneys have played a role in the bioethics seminar series, and this episode and last one are a case in point. Lawyers work in the sector of bioethics, and there aren't that many colleagues in this field of specialization. Most tend to work for pharmaceuticals or private companies that may finance clinical trials. So that means that when negotiating, there may be some asymmetries when you're dealing with institutions that have their own legal team, or they have a lawyer that has a more general background and deals with many different types of matters, or also the research committee attorney who may cover matters pertaining to those trials. This may lead to some conflicts of interest and may lead to questioning the role played by attorneys in this context. Usually, this asymmetry is even more pronounced when it comes to research teams. They don't have their own legal counsel and may not be in a strong position to negotiate or analyze issues and negotiate a contract accordingly. So this leads to asymmetries. It also leads to delays in the process. And this also means missed opportunities for the region and for centers that don't have that much expertise in negotiating contracts. So the template we are presenting today is meant to be a tool which we hope will generate some basic consensus. It will offer standards and clauses that tend to be used in the context of clinical trial contracts. It's a conventional model. It involves the institution, the investigator, and the participants. It basically can be used modularly. It's just an example of a document that can be used for different types of association relationships or partnering. So the idea is to show you the core clauses so that you can all have access to them. They should just be a reference for legal teams and even for people who don't usually work with legal concepts but need to have a basic understanding of what should be in a contract for a collaborative research clinical trial. So after this introduction, I will give the floor to different experts so they can speak to what I have just described. I will ask them basically how we can optimize, implement, or envisage using a template like this for contracts in the region. I'd like to start by introducing Enriqueta Pearson. She's an attorney. She works with ANMAT. She's been there for many years, since 1995, and I'd like to invite her to take the floor and share her opinions with us, and then we'll move on to another guest speaker. Good morning, everyone. I appreciate first the invitation to participate in this seminar and also the introduction. I echo the comments made at the outset. And as Adriel said, I've been working for many years with ANMAT, and my focus in my legal work until last year was clinical trials. From my vantage point, I've seen how ANMAT developed its regulations starting in 1985. The first full regulations were issued in 1995, and these included national, or rather international, standards for clinical trials, taking into account the work being done by countries that had high surveillance and also applying the ICH standard. And now, since we have regulations since 2010, and these are currently under review. The idea was to provide maximum compliance with international and national regulations, focusing on the patient. And the clauses that are being proposed in this contract template is, at least in the case of Argentina, is meant to consider all the legal responsibilities, all the liabilities that must be covered by the sponsor and by the principal investigator. Now, in the case of the contract and the national regulatory authority and the connection between the two, these contracts are not considered a requirement by the health authority, meaning by ANMAT, nor do we require a modern or model policy. We do look at the contract, and we do have a requirement for clauses that should be included, and one is that there should be the number of the insurance policy and the insurance company providing the policy. And this is an insurance policy contracted by the sponsor. What I would like to present is the following, and Carlos also said this. In clinical trials, we have a series of actions by many different parties. And what I wanted to emphasize is that these actions are not always within the purview of the national regulatory authority, which is authorizing the clinical trial. What I mean is the healthcare institutions where the study is being carried out, ethics committees, the professionals acting as researchers in the trial, and I mean those who are responsible for the registration of those who are authorized to practice. In our case, it's not ANMAT, it's a different agency. So there's many different legal relationships at play. I would like to single out one player, which at least in Argentina is currently very important, and that is the different jurisdictions. Because of the way Argentina is organized, we are a federal state. We have 24 different jurisdictions, including provinces and city governments, and they have health care authorities. Currently, the current an applicable standard for clinical trials is under review. And what we are trying to do is to engage the jurisdictions, have them participate based on their constitutional authorities, and this would also involve their ethics committees. So the idea we have been working on is to have the health authorities involved in providing authorizations either through their ethics committees or other agencies. This means that trials that have been authorized by the jurisdictions should specify the institution that is going to conduct the trials, specifying that the institution meets the core requirements to proceed with the trial. And the same would apply to the skills and competencies of the investigator and his or her team. This has already been attempted in other regulations with the 2018 version, but we have not been able to fully achieve that objective. So what I would propose here is that we consider the challenge this poses. These clauses, especially the ones that refer to the sponsors and the investigators' responsibilities, which were very well described by Carlos, are covered in the ANMAT legal provision regulating clinical trials, but generically, and focusing specifically on respecting the rights and dignity of the patients and participants. So I think the challenge lies in how to have the jurisdictions and the ethics committee develop the competencies they need in order to work with contracts and with insurance policies so that the final authorization for clinical trials can be properly obtained and within acceptable time periods, which is yet another major challenge we face. And that is why I believe that the template you are proposing, which you've worked on with Bajo, is a very useful tool, in my opinion, to meet the essential requirements to expedite participation by the other players I've described. And I think this will also lay the foundation for other regulations to be developed by countries in the region in other sectors. This may contribute to expediting the process. As for the other clauses mentioned by Carlos, I have worked with him, and we have stressed the importance of ensuring that institutions do have the necessary resources, that they're able to provide the infrastructure needed for the trial. So that is what I wanted to say. I think we do have a major challenge to deal with, making sure that all those involved have the necessary qualifications. And I do think this contract template can help make sure that each country in the region is in a position to perform these steps adequately and within a reasonable time frame. Thank you very much, Adriel. Thank you, Enriqueta, for your views. I would now like to call on Luis Felipe Reyes. He is an investigator. He's with the Zavala University, and also he's been with Oxford University. Luis, go ahead. Thank you very much, Adriel, and thank you for the invitation. As I was listening to the lawyers, I was thinking that the details of the contracts and clauses are a key component when it comes to implementing research trials. And I think of how we at the university and at the clinic work with lawyers whenever we have to sign contracts to conduct collaborative research trials. And we tend to come back to the same discussions. We talk about intellectual property clauses. We talk about the insurance policies we need to have in place. And as was just said, there is a growing concern regarding malpractice and malpractice insurance. So these are items we find increasingly often in contracts in our discussions with lawyers. So having a contract template like the one Pajo is proposing would be a huge advantage in my view. It would help us clarify concepts. I believe that Pajo has a huge advantage and a huge responsibility as well. And it stems from the fact that our countries, our member countries, and the universities in those countries are very receptive to ideas that come from Pajo. So having a model, having a template for this contract, I think will facilitate things at the country level. And the parties involved in research trials, I think, will benefit from having clear concepts and knowing that when Pajo offers us instructions or proposals, that adds value and also makes it easier for people to embrace. But I do have questions about how or if these templates can be implemented. Why do I say this? Well, because I work with the Universidad de La Sabana in Bogota, Colombia, and we have collaborative agreements with many different institutions. They include the Wellcome Trust, the Gates Foundation, and even Oxford University. So there's a very broad gamut, and they each use their own preset contracts. So my question is, how can we align what we are proposing here or what Bajo is proposing, and the contracts already in use by these major institutions. I think this is a key point because in Latin America and elsewhere, in settings where resources are limited, most of the funding comes from large financial institutions. It could be the NIH from the United States, the Wellcome Trust, the Gates Foundation, Horizonte. So there are many different leading sources, and they already have an established contract model. And even though we may be part of the team that designs the project or comes up with the idea, we end up signing contracts with these institutions that have their own established contracts. The same is true of universities. We were recently looking at a contract we signed with the University of Toronto to conduct a research trial. And like other international contracts, there were differences when it came to definitions. There were also inconsistencies in the definition of the responsibilities of the ethics committee, of the principal researcher, etc. And when I say that there were differences, it means that the concepts we have at our universities in Colombia are different from those used by international institutions or financing sources. So this puts us at a disadvantage. They have the resources, they sponsor projects, and we need to have not only a template for contracts, but a way of aligning our contracts with those of multinational institutions or with universities and institutes that are in other countries. So this is essential. We do have contract models. We do have institutional policies in Latin America when it comes to collaborative contracts, but whenever we are dealing with sponsors, with those who are providing funding for projects, we see that there's a major misalignment. So that's what I'd like to say. We need to do more than simply propose a contract model. We need to have an implementation plan. And I think that that is important for us as researchers. We need to understand what happens with contracts, with the negotiated contracts, with individual and collective responsibilities that are part of this process and are reflected in the contracts. But again, what concerns us the most is how to implement contracts that are aligned with and comparable with those we have in the region, especially when we work with international institutions. So that will be the next step. Once we agree on a template that is applicable for the region and for its needs, then we also need to find a way to cover all the different roles and responsibilities and align them with those used by leading financial institutions and also with the major universities that usually are generating science projects worldwide. And maybe that is something we can discuss further later. Thank you.
Thank you very much, Luis. I think you touched on a very interesting point that is also very impactful. In fact, the implementation challenges will be the next step once we get to a consensus on the content and we present the tool, the model contract template. We'll move on to the next step and we will clearly see some challenges. We need to be able to find a way to establish consensus and be able to implement these projects. It's really a strategic matter, but it's very important for us to have common provisions. Let me now introduce Paula Pulgarin, who is a project specialist for the Colombian Regulatory Agency, and she works with the network in Colombia, Mexico, and Peru. Go ahead, Paula. Hello, Adriel. Good morning. Thank you to everyone, and especially to PAHO for the invitation to take part in this seminar. As you mentioned it at the beginning, the contribution I have is more technical than legal, and I'd like to begin by saying that in the case of Colombia, the health agency does require the presentation or the submission of a contract and budget for regulatory aspects. If it doesn't necessarily include just the documentation related to the project, but the agency is interested in the agreement between the different parties that are in the contract for the clinical trial, and we want to always ensure the safety of participants. Now, when the submission is first made, when the contract and the policy are both signed, then we can then move forward. But sometimes the processes can be done in parallel, and the agency can receive a draft while the ethics committee undertake the necessary actions that fall under their purview. Now, when we talk about developing a template with a mind to make it regional, I think this is very positive because we don't have any guidelines or instructions that shed light on this topic. In fact, this is a gray area that is subject to interpretation. Or we can also have something akin to how we say it in Colombia, la pelota, where the legal entities for the different research centers always adhere to the macro contracts that have been established since we started working with pharmaceutical companies. Now, what happens is that when you have a baseline document and a checklist that could be useful to the research centers, many times they don't have a solid legal team that is also experienced, because in addition to the fact that finding attorneys that are experienced in clinical legal issues, when we undertake a project, we could use them as a reference to address the legal issues as well as the binding issues, and it could be a minimum guideline that would be desirable for assessing the viability of these projects. The other point that relates to what these standardized documents can contribute. Hopefully, we could add additional important points, but we do have this perception that the regulatory timeframes for the initiation of a clinical style or a clinical trial depends only on the region. But in Colombia, we've conducted a number of studies that indicate that 45% of the regulatory timelines that a protocol takes from initiation of the feasibility study to the approval of the clinical trial does not depend only on the health agency, that 40% relies on the research center and managing all of the paperwork and activities prior to the initiation of the clinical trial. This includes the contract negotiation and the establishment of terms and what have you. So this allows us a tool that will make this regulatory timeline that is not agency dependent, but rather more dependent on sponsors or the research institution. Now, if we were to reduce the time it takes to review the contract, the budget, and all the terms included therein, then days, weeks, or months can help close the gap that we see in many countries in the region and will ensure greater efficiency and by extension will ensure a larger number of clinical studies and clinical trials. Another characteristic that could be helpful, having a baseline document such as this one, relates to those cases whereby sponsorship is not coming from a large pharmaceutical industry entity, but rather a grant or some other organization that operates in the research realm. And they may have resources to contribute to a study, but many times research centers don't have a baseline to determine how to negotiate the deliverables for these studies and how to have a mapping of all of the risks involved with clinical developments. So these studies that are carried out primarily with academic institutions or high-level research centers would find this document very useful, and it would allow them to understand those basic fundamental lines or items to enter into a contract. So based on that, they can look at the implementation and the positive impact that could be brought about through these initiatives, or the reduction of the time involved in putting all of this together to carry out a clinical trial in the region could allow us to perhaps come up with a way to measure the impact, and we could perhaps see what the impact would be for all research centers and through some subset of recommendations or guidelines, both by health agencies or research institutions, they would then be more prone to use these instruments with greater frequency. That's what I wanted to say today. Thank you. Thank you very much, Paola. And just to conclude, we will hear the health institution perspective. We have Daniel Barta, also an attorney, and he will share some insights with us. We don't have any audio, unfortunately, for Daniel.
Your audio is not working, Daniel. No, Daniel, we can't hear you.
Bien. Bueno, mientras Daniel intenta resolver, yo
Well,
aprovecho el
while
espacio
Daniel works on his technical issues, I'd like to take advantage of the moment
a los
to
expositores.
remind our
Pueden utilizar el
participants
espacio
that if you have any
preguntas,
questions or comments
aparte de
for our
comentarios
presenters,
que estamos leyendo
please
dentro
submit them through the
de lo que
Q&A
hablamos
function,
para luego discutir en la parte final
and
del
we
evento.
will then refer to the Q&A to answer some of your questions and respond to some of your comments.
Now it's possible to hear me. It's okay.
Ahora sí, Daniel. Adelante.
Sorry for the problem here. First of all, thank you very much for the invitation to participate in this important initiative. My comments are in line with Adriel first comment and also Luis Felipe when they mentioned some asymmetries between the companies and the organizations that come to the institutions to provide the clinical studies. So I will focus on a very practical point first. While we agree with the benefits of having a model clinical trial agreement, in many cases, the sponsor, usually a pharmaceutical company or an unauthorized intermediary, approaches the researcher directly with their own contract template. Already, they argue that it's already pre-approved by the legal department. They claim that it cannot be changed. So the challenge here is the institution may not have the bargaining power to impose their own model. Although I agree, we understand that the model that we are proposing, it's a tool. It's not it must be adapted by the institution, of course. But we might not have the bargaining power to impose our model because of time constraints, strategic interest, or the specific context of the study. So I think it's important to recognize that, and that we must ensure that institutions are internally prepared not only to use the model when possible, but also to analyze, adapt, and negotiate clauses in third-party templates. This means understanding what is essential, even if the model contract isn't used in full. I will highlight some critical elements that in the case of Fiocruz, we look for in even if we are making our own templates or models, or we are working on a third-party template. The clear distribution of the responsibilities to try to limit the personal liability of the principal investigation, unless it's legally required, of course. The institution should be responsible for the institutional commitments in the contract, and to provide some safeguard when possible to the principal investigation, because it's the weak point, it's the weak person in this whole arrangement, the contractual arrangement, and we try to recognize that. Also, the fair and sufficient financial compensation, and so that assure that the payment should cover all the costs, use of infrastructure, personnel, equipment, depreciation, intellectual contribution. And we understand that in some instances, it depends on the case, but in some instances, we are working to the benefit of huge companies, and they benefit from the intellectual property or the intellectual training that the institution or the infrastructure or the access to the patients that the institution have for their own commercial benefits. So we understand that when the relationship is not characterized as a collaboration, it's only in the main benefit, although that the institution benefits a little bit with the arrangement that performing the clinical study or publishing the results. The main benefit relies on the company, on the industry, on the pharmaceutical company. So we believe that we must consider that this financial compensation also includes some provisions for reinvestment in institutional R&D. So it's this one position that we have inside our institution. Also, of course, what was mentioned, reasonable publication rights. The companies should have the authority to review the publication, but we must provide clear deadlines, the tacit approval if no response is given, which has happened before with us. And also to consider that academic freedom and transparency are at stake in this kind of relationship. Also, one important thing that we consider is the control over brand and identity use. The institution name, logo, affiliation should not be used for promotional purposes whatsoever without our prior written consent. We can use the name of the institution when in regard to regulatory use, but not commercial exposure from those companies. The compliance with national laws, which was already mentioned, that the model should be adapted by the institutions that are going to use it, including laws on insurance, indemnification, and ethics, this should be a major concern. And also the safeguards in regards to intellectual property infringements, that when we receive a model from the third party, usually this is not well addressed. They don't want to be responsible for the products that they are using, that are proprietary products used in the study. So this is an important point. Even when a company refuses to adopt a model agreement, participation in the study may be strategic. It may be important for the institution to participate. So this kind of approach, recognizing that sometimes we won't be able to use our model, and we can use it as a reference for the negotiation, and to try to adapt it for a more reasonable conditions, or also to understand what the party is proposing, the risks. If the institution understand the risks, they can be managed, or else the institution can decline to work in a clinical study that is not reasonable, and then provides a lot of risks to participate. So, of course, I agree that the model agreement is very important. Should be used as a reference, not a rigid requirement, of course. As a tool to negotiate better contracts, and understanding the kind of relationships that the institutions are involved when a third party, or in some cases relating to a grant, international grant, is presented to be performed. Okay, this is my main comments. I agree. I thank you very much for the opportunity.
Muchas gracias, Daniel, por
Thank
compartir
you very much,
tu
Daniel,
experiencia
for sharing your
en
experience
Creo que también
and
es
giving
sumamente
us the
valioso
institutional standpoint. I think this is valuable input, and it's very important for us to consider this. Now I'd like to invite Sara Saracedo and Carlos Burger to join us in trying or in attempting to answer the many questions that we've received throughout the course of the activity. Let me start with the first one that has to do with the model that we will be sharing, this model contract, and ask if there is any restriction or recommendation for the use of this model contract, or is it a generic tool that can be applied to any and all clinical trial? Thank you, Daniel. I can perhaps start by answering this question. When we worked on this model contract, in principle, we thought about those contracts that are necessary for clinical trials that are governed by good clinical practices. So clinical trials with medications, devices, or other health initiatives that will involve a national health authority. Now, we also know that there are other types of clinical trials and research that may require contracts, and I believe that that type of contract can include, or this contract includes a lot of clauses that can be used as a reference for other types of research contracts. But this one was designed in keeping in mind these types of clinical trials, and it was also designed with a mind to improve the frequency of clinical trials. Despite this, many clauses do have that essential content that we need to be looking for whenever we negotiate or when we sign on to an agreement. And we can always use this template as a reference to engage in other types of contractual arrangements. I don't know if Carlos would like to elaborate a little further. No, I think that was very clear. The idea, as Daniel was saying, is to reinforce this idea. The template is an essential tool that will allow any institution to negotiate terms. We all understand the main points, and we all understand the main challenges, especially related to challenges. We've talked about the assignment of responsibilities, intellectual property, how to use names, logos, how to manage publications, the rights, the transparency, the mechanism for sharing data, and the entire research process. All of this can be included in this template because we've already considered this. And as Sara mentioned, we could use this model to discuss these different clauses or provisions. Let's remember that we are talking about a contract whereby the parties come to an agreement. In many countries, we have mandatory issues, and we've reviewed all of these, and all of them have to do with good practices. This includes liability, coverage for any adverse events, financing, and this is what we have in common. So we can start with this template, and then we can move on to the fine print, depending on the circumstances and depending on the parties. Excuse me, Adrian, I did want to mention something else that Carlos just mentioned, and that is that this model contract also has this perspective of strengthening the role of institutions when they carry out research. And Daniel was talking about this. Not all institutions have the same power of negotiation. Institutional commitments with researchers in each institution are very different. It depends on the role that they have in the research. And so with that in mind, the idea would be to all of us as an institution be able to carry out the negotiation of better contracts that will be more fair for everybody involved. And the idea would be to make this more fair for the institution. So the institution isn't merely there to receive the research, but also to take part in the management of the clinical trial to be executed. So this is a flexible model that recognizes these differences in the degree of maturity for different institutions that conduct research in the region. And as we stated, and as Carlos mentioned, these are eminently adjustable in the template. Something that I wanted to address based on the last thing you said, Sara, I think it would be very prudent for institutions to participate in their contract development. And regardless of each institutional model, but it can happen that a researcher comes to an arrangement with a sponsor, and by the time it gets to the institution, the contract's already put together, and all that requires is a signature by the institution. And many times when the institution takes part in the process from the outset, then the outcomes are much better. Because in that way, the institution will have a better negotiating power. Now, I'd like to talk about various questions that we've been receiving here, but I want to ask, what role do you believe the research committee needs to have related to not just the contract, but also the guidelines and the policies? Regardless of any local legislation or standards in place, what is the role that the research committee needs to have in all of these documents? Well, let me get started with that. I think that when we talk about contracts, research contracts for clinical trials, the committee, I don't think, has a role. This is more of an institutional role. It's more of a role for the legal advisor's office, and the policy, what the committee is interested in knowing is whether or not the research is ethically acceptable, and they also want to make sure that they are protected against any liability due to any harm caused by the study or any negligence on the part of a researcher or the institution. So the idea for reviewing this policy was to ensure that these mechanisms are in place to guarantee that participants are in effect plainly protected in the face of any of these potential outcomes. It's not so much that committees will have more of an advocacy role. They won't necessarily have any legal scrutiny over the policy, but they need to get to the crux of the matter and identify the responsibility issues in case there are any adverse impacts to participants. And in terms of administrative, logistical, operational components of the research, the researcher and the institution really take the lead on those. The research committee doesn't really have a role in that. So the committee needs to be focused on the review process and monitoring the study based on the provisions and guidelines outlined in the contract. That's what I believe the role of the committee is. Carlos? Well, I think that we were talking earlier about how we have different legal frameworks in the region. In Argentina, there is an obligation imposed on research ethics committees some points. Clearly, the committee doesn't have to review the entire contract, but if you agree that if there's no committee, or rather, it would be possible for the committee to review the protocol, anything required by the institution, framed within ethical considerations. We understand that there's a great deal of divergence between an opinion coming out of the legal office versus the opinion coming out of the ethics committee. When we talk about a protocol, we need first and foremost the consent by the participant. And so the analysis of the contract that needs to involve those issues that are most relevant. So something that involves the ethics committee and the legal office is something that's very specific. And in the case of Argentina, it ended up falling into under the purview of the ethics committee. So we need to have a very fluid communication between the legal office and the committee to ensure that all of the protections are in place. In many cases, I've served as an attorney in the ethics committee, and in some places they require somebody with a legal background as part of the committee. But when an attorney is called upon to assess a contract based on ethical considerations, it can be something that generates conflicts of interest. Because when you're talking about a contract, that's not what the institution is looking for. Many times you're just looking to assess a protocol that's linked to that contract. So we need to leave that to the legal team or the office of the legal advisor, or other issues that pertain to that particular space. If you will allow me, I think that, as you were saying, the attorney does not have to take part in the negotiation. But I was just referring to the current law in Argentina. The committee is not the space where the negotiation takes place for the contract, but the committee can issue the technical aspects that need to be supported in the contract, and it can issue recommendations that can be then accepted by the contract negotiation people. Now, even though in Argentina we have some standards that allow some authority to the committee, they still always defer to the legal office for the legal considerations. I was saying that the object for today's webinar was to present a model contract template, but anything related to insurance involving research will naturally engender many questions. So I'd like to ask both of you, starting with Carlos, what is important that needs to be contained in a policy? What does it cover? Does it cover all the parties or just the research team? What is the most important when we look at the policies for these insurance policies?
I would say that there's a great deal of confusion regarding the role played by insurance policies and how these policies connect with those who may be harmed in a study. Let me explain. We need to start out by understanding that the sponsor is responsible for any damages caused by the trial. Therefore, it is the sponsor who needs to have as broad a coverage as possible. The sponsor is always going to be liable. We could also consider other situations, and I think somebody asked this in the chat. What happens with policies and what causes or triggers policy coverage in the country? Well, it's the sponsor who has to trigger the application of the policy. And you will see that in the contract we are proposing, there's a clause regarding contracting an insurance policy and then a generic clause, which spells out who is responsible for different parts, for the drugs and for the different steps in the trial. So what this means is that the sponsor is the liable party, but the sponsor has to contract a policy that will cover what happens when coverage is required. What this means is that the sponsor has to have the resources to respond. The other problem we see is that when there is an insurance policy, it is limited to paying for medical treatment. These policies work like any other policies. You have immediate damages that must be compensated, but that does not mean that there isn't going to be liability, civil liability for harm that is not immediately assigned. For example, if a party requires clinical treatment for an adverse event related to the trial, then the insurance policy is going to be activated, or the sponsor is going to provide payment or compensation. If there is any legal action, that legal action may or may not involve the insurance depending on the type of policy contracted by the sponsor. But what we need to understand is what the insurance policy does is provide coverage for the institution and for the investigator. The insurance policy covers the sponsor in the event of claims. And it also would involve the institution and the investigator. If there is a legal claim involving the institution or the investigator, the sponsor using the insurance policy would also provide coverage for those. I think there was also a question about the amounts. The amounts are not set based on the views of the committee or based on standard practice. The amounts have to do with a number of things. One, the level of risk of the trial, and secondly, the frequency of the risk, which is based on a statistical analysis. And it has to do with the value of life that is set in the laws of the country where the trial is taking place. So it's very hard for a committee to determine upfront what insurance policy coverage is going to be sufficient. It's quite complicated to do. So what should matter to the committee or to the regulatory agency is the following. The liable party is the sponsor, and we're going to require a policy that will provide liability for compensation. If the sponsor had the bad idea of contracting an insurance which did not provide for sufficient coverage because the risk of the trial was not properly assessed, someone is going to have to pay. Therefore, it is not possible, or there has to be full liability. So it's risky being a sponsor when it comes to clinical trials. It's important for the sponsors to assess the risks involved. Who should assess the risk? Can anyone do it? Or does the company need to have sufficient coverage? As was mentioned, clinical trials are often conducted by pharmaceutical companies. Why? Because they have the resources and they have the know-how to do so. It is what happens, in fact. We're speaking of liability coverage. It's not just liability for damages. It's important for the liable party to have the resources. If the insurance policy is good, there is no issue, but that is not a matter for the committee. It is something that has to be discussed during negotiations, and the focus has to be on the institution because the institution and the PI are being hired by someone else to conduct an activity, and they're doing so in the context of uncertainty. So if the sponsor is not providing sufficient coverage, it's not just an ethical issue, there's a financial and liability issue at hand. I have several questions about insurance policies. Everything you said is related to the insurance policy contracted by the sponsor to cover all the damages that may arise from the clinical trial and the protocols implementation. And so this relates to the product of the investigation. What happens to damages stemming from negligence of the medical team or bad intent or serious negligence? What happens when the product is misused or there isn't compliance with the protocol? Would insurance policies cover this as well, or do you need to have a different type of insurance? It is a different type of insurance. That is why I said that what our contract model does is to ensure that there's a professional liability insurance, because what the sponsor does is provide coverage for a potential risk associated with an idea or a risky activity, and all of this happens in a context of uncertainty. There is a drug under development that may be harmful in a way that is not yet known. So the liability lies with the person or institution that had the original idea for the project. But there could be an issue of negligence or improper action that may lead to harm that was not contemplated in the protocol and that is not related to the drug or the protocol. There was improper action. So malpractice by the researcher affects the institution because the institution hires a professional who in this case has decided based on a contract to conduct a clinical trial that is supervised by the institution, but that professional may act in a manner that is considered negligent. So the institution that hired that professional is going to be affected and is going to be a part of the malpractice suit. That is why we highly recommend that there be malpractice insurance for the sponsor. That will also cover the institution. The sponsor is going to say, I'm liable if my molecule, let us say, caused the harm. But if the execution caused the harm, then it's different. The sponsor should not be responsible for such harm, and that is covered by the clause we included in the contract, and it exempts the sponsor from blame when the researcher is at fault. And that has to be specified. It's highly advisable. I would say that most contracts today have malpractice insurance, even though it is not 100% required. And there could even be collective policies for professionals. This is one way to provide protection, but we think that some committees may be somewhat confused. They think that policies cover the sponsor, but that is not malpractice insurance. That is a different kind of insurance, and it has to be included. Sorry, Adriel, if I go on a bit more, you asked about certificates of coverage. What we see in those certificates is that there is protection afforded, for example, concerning compensation for those who contract the policy. It's the sponsor that is insured, but the certificate of coverage can include the institution and the investigator against potential claims. I think it's important to consider the type of clause included in the policy and also the certificates of coverage, which may only cover the period covered by the insurance policy. It is important to include the period that is covered by the clinical trial. So it is not just an administrative coverage. The policy has to provide further coverage, which is activated or is effective. In our country, we have some policies that say that the policy enters into effect from the very beginning of a trial and is effective until the completion of the trial. That was very clear, Carlos. I think that we have fully covered the questions about insurance policies. Now, in terms of severe adverse events, should there be a specific clause in the contracts regarding these events? What should that clause include? The clauses we have on adverse events specify that adverse events must be reported to the national regulatory agency in keeping with the relevant regulations. As I said, this contract is not meant to repeat or replace what is already in those regulations. So the format and the other details are covered in clinical trials regulations and laws, in agreements that are already in place. Therefore, the contract only states that should there be adverse events, they should be reported appropriately in keeping with the relevant regulations. And I think that the contract seeks to balance that. It avoids repeating what is already covered by national standards and regulations, but rather focus on content that is to regulate the rights and responsibilities of the parties involved. That is why it doesn't specifically speak to that. It simply refers back to existing and applicable regulation. I agree with Sara. That was the idea. If the adverse event must be reported according to national regulations within a set time frame, that is what is required. It's mentioned only generically, as Sara said. I did not mention it in my presentation because I think it was self-evident and there had not been much discussion about this. So I focused on the points that the team discussed or the items that our external advisors had made comments about. But as Sara said, it is something that has been properly addressed. I'd like to ask about the roles of the different parties and their responsibilities or liability. Is it appropriate for an institution not to have any liability, to have full liability lie with the principal investigator, meaning that the institution would not be liable for anything else other than providing access to facilities and infrastructure? What are your views about this? Maybe I can start because it is something I did mention at the beginning. We focus and we emphasize the active role to be played by the institution, so we have left out the possibility of not including the institution in a research trial contract. Why? If we want to promote research, if we want to conduct research trials in keeping with the top ethical and scientific standards, it is important for institutions to be involved from the very beginning and until the end of research trial. The responsibility falls on the institution because it is the place where the trial is being carried out. The principal investigator should not be fully responsible for negotiating and doing anything he or she wants. As a result of those negotiations, there is an institutional responsibility. The investigators should have a connection to the institution in order to lead the research trial. So we did not consider the possibility of leaving out the institution from the agreement. Rather, we want to enhance its role and ensure that the institution is involved from the get-go, as you said, Adriel, even before the agreement is reached. The institution should be a party to the negotiations. It should have the capacity and the qualifications in order to serve as a venue for the research trial. I agree with Sara. There's an issue of who should have the responsibility. If I have an investigator under contract, let's say I'm the institution, and there's a dependence agreement, there's been independent contracting, etc., but I make this professional available to the community working in my institution on a research project, I have to be responsible as an institution given that role. So maybe there could be an institution that's come up with the idea of adding a clause which says even if there is a claim covering both the institution and the investigator, liability will be solely with the investigator. It will also depend on the civil liability arrangement in the country. We would have to comply with a national regulation. We have spoken about ethics and ICH, and in those cases, the institution is a liable party. It does have a role to play and therefore cannot be exempt of responsibility. There could be a minimum risk protocol, there could be other arrangements, but I think the outcome is going to be exactly the same. It is highly unlikely that this will happen. And if it is something the institution proposes, we'd have to make sure that it's consistent with the existing civil liability regime in the country. There's another question, and I know that it depends on each country's legal system, but nonetheless, it is something we could discuss theoretically. If the sponsors do not have a subsidiary in the country where the trial is going to be conducted, let's say the contract is an international contract, the parties are in different jurisdictions, how would that model work? Do you think it is a feasible arrangement? And in such cases, what would have to be considered specifically? I just have a few comments. Maybe Carlos can speak to this in more detail. I think that the national regulatory authorities, when authorizing a clinical trial, have to ensure that the sponsor has a local legal representative. If anything happens, if anything is needed, someone has to be responsible. It can't just be a party that is outside the country. How would that work with discharging responsibilities? The same is true with the policies. With insurance policy, I remember a case where there were countries that had external insurance policies because there were none in the country for clinical trials, and applying or executing those insurance policies was difficult and even impossible. Nobody knew how to do it. So it is something that is necessary. There has to be a legal representative locally. Not having that would complicate discharging responsibilities in the context of the clinical trials while ensuring full protection of participants. What Sara is saying is very interesting. We have seen projects in some jurisdictions. They require that the sponsor be registered in the country and have a legal representative locally, having a local domicile in the country, and therefore be required to contract an insurance policy locally. Also, there has to be a registry of sponsors and companies, and they must have a specific domicile that is registered. But it really depends on where the harm occurs. Sometimes it is not possible to have a civil liability regime from one country be applied in a different country. We are speaking of responsibility for damages related to the protocol, damages to the participants. Now, if we speak of a contractual liability for compliance with contracts, and I'm not referring to adverse events. Participants are not parties to the contract. Therefore, what is specified under the jurisdiction does not apply to them. It's important to consider where the harm has happened, but if there's payments are not made, which are legal responsibility, but they're part of the contract, that is different. Because you could determine that there is external jurisdiction, you could use the contract regime that applies there. But what we recommend is that the model be applicable and subject to local law. That is why we suggest including a clause that says contracts will be governed by local legislation for the research center. And in Argentina, this is something that is mandatory according to the good clinical practice regulations in place. Excellent, thank you. I'd just like to add that in the model we're going to be sharing, that is covered. We say that the courts that have competency where the harm happens, so if it happens elsewhere, it also says that the official language of the country should apply if there are different language versions. So the legislation that applies is legislation in the place where the trial is being conducted. It's the easiest way to interpret applicable regulations. We have many more questions. I think that this is a topic that will call for a lot of discussion. And with that, I end my part and give the floor back to Carla for the conclusion. Thank you very much, colleagues, and thank you to Carlos, Adriel, Sarah, for the work you've done. I think this is going to be very useful for the region. I'd like to talk about next steps, but before I do that, I would like to briefly reiterate how important it is for PAHO, because we know the prevailing scenarios. We also know what we are lacking in terms of qualifications, and we think that having a fair contract is going to help us transition to a better research ecosystem in the region. We know that we are working really hard in the region to promote research and conduct research in a part where we have some bodies doing work that is not within their purview, for example, ethics committee, and it's for lack of someone to do it. And as Sarah said at one point, what we're aiming for is a way to do things better, a scenario where our research capabilities, our research ecosystem is strengthened and is in a better position to carry out research, to start research in the region, and undertake large-scale research with the region's leadership, which will enable us to produce knowledge that will improve the health and well-being of our people. As next steps, we are starting to review the model we have shared with you today. We are going to be taking another round of comments from our technical working group. We have taken due note of your comments and questions. And there's two things I'd like to clarify, if I may. One is that the product we're working on, like my colleague said, is something that would be responsive to what we see mostly in the region, to the region's most pressing needs. But we also are aware that there may be some specific context or scenarios that may call for some adjustment. So we are thinking of a publication which will include the model contract template, as well as special cases or special scenarios. If you are in context X, you should also consider X or Y. And in cases where there may be specific difficulties, we are adding definitions that could help address those. So that is my first point. My second point is that we will be using the research and ethics list to share the recording of this meeting, as well as information on how to submit comments to the draft document we have right now. We hope to have comments within a month. After that, we will proceed with a review and will ultimately proceed with publication. I do want to thank you once again I invite you to continue to share your input. This is truly a regional effort. I also would like to thank our interpreters who have made this conversation possible, and also all colleagues working behind the scenes, not only to make this session possible, but for enabling us to share the video subsequently. I invite you to join us for the next virtual seminar on another very important topic for the promotion of research in the region and its pre-approved protocols. This will take place on June 18th, and we will be sending out invitations using the ethics invitation list. Thank you very much and have a very good afternoon.